I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. On today's episode, we are discussing AI and antitrust law. It's a continuation on one of the most important trends in today's data legal world. In our digital world, data seemingly touches everything. And if predictions are accurate, now so will AI. So it wouldn't be any surprise that regulation of data is much broader than privacy, cyber, and other aspects of data protection. And similarly, while there are AI-specific laws on the horizon, the regulation of AI will be much broader than those specialized laws. There are just so many places for data and AI-focused lawyers today that really require a multidisciplinary approach. And I wanted to focus today on a big one, antitrust. Competition regulators around the world, especially those in the EU, have focused on the impact that large concentrated data sets can have on markets. And while that focus will continue, another issue has emerged. Do publicized advanced developments in AI, in combination with those large data sets or other unique technologies, create unique antitrust and competition issues? Or maybe put another way, do companies who have established large footprints in digital markets enjoy an unfair position in the development of AI and the commercialization of AI-related products? These issues are top of mind for many in the space and really important for you to know as you work with your stakeholders on how to manage them. To discuss, I've invited two of my colleagues, Edith Ramirez and Chris Fitzpatrick, to the podcast. Edith is a partner in our antitrust and privacy and cybersecurity practice groups. She's a former chairwoman of the FTC in the Obama administration. You won't find anybody who's more expert in these issues than Edith. Chris is a senior associate in our antitrust group. He's an antitrust litigator, represents clients in high-stakes competition matters, and advises companies in both the tech and transportation sectors on competition risk. Edith and Chris, welcome to the podcast.
Thanks, Scott. It's really great to be here with you.
So let's just dive right in. And maybe, Edith, I can ask you, maybe setting the groundwork for us, why is AI a competition issue? What is at the heart of the concern of the regulators in this space?
So, Scott, I think you laid out a good part of the concern in your opening, but let me start by saying a few things. I think it's important to understand that there is a lot of excitement about these new advanced AI technologies. I heard one antitrust official note that it's refreshing to be talking about new and different companies today than just a few years ago. But there is also recognition that advanced AI technologies, they may have enormous potential to disrupt and to transform the economy and society. There's also a worry that they could amplify existing competitive dynamics in digital markets and extend the economic power of large tech companies. So to delve into that issue and set of issues in more depth, I'd like to frame the discussion by making two key points. One relates to the mindset of antitrust officials and enforcers around the globe. The attention that's been placed today on advanced AI technologies, it's not just simply a continuation or extension of the focus that we've seen on digital markets for the last 15, 20 plus years. There's also a view among antitrust officials that enforcers were slow to appreciate and to take action to address the competitive issues arising in digital markets. And I think that's produced a sense of urgency to keep a very close eye from a competition perspective on this potentially transformative technology. So I think that mindset is very important. I think there's going to be a sense that they have to act sooner rather than later. Then I think the other key set of issues to keep in mind have to do with the structural reality with respect to the development of foundation models. There's a very significant concern that control over critical inputs that are necessary to build foundation models are held by a small number of players, making it very challenging for small innovators to compete with them. So we go through and discuss the three key inputs that are critical here and that people are talking about. Number one would be computing power. Computational resources are scarce, and they can be a bottleneck in both the training of large-scale AI models and the deployment of those models. And there are just a handful of companies that have control over those resources. You have chip designers like NVIDIA, chip fabricators like Taiwan Semiconductor Manufacturing, and then you have the cloud infrastructure firms. So that's one piece of it. The other is data, which you've also noted, Scott, but without data, there is no machine learning, and generative AI requires extraordinarily large data sets. And then there's the talent that you need. You need very specialized expertise in order to develop these foundation models. And an interesting development in this space and high tech generally are deals that are referred to as acqui-hires that are focused on the acquisition of key talent. And so those are becoming increasingly common. So in order for smaller players to get access to these critical inputs and compete in this space and innovate in this space, increasingly you see them partnering with large tech players. And let me hand it over to Chris, who can speak a little bit more about what we're seeing in that respect.
Thanks, Edith. And I think that's absolutely right. There's been concerns about consolidation in the industry being effectuated through these partnerships that you described. In January, for example, the FTC launched a Section 6B investigation into AI investments and partnerships between the large tech firms that you referenced and AI companies, labs like OpenAI and Anthropic that are leading the charge in a lot of the advanced models that are driving this technology forward. And we've seen that not just in the US with regulators like the FTC, but across the globe. The Competition and Markets Authority in the UK also announced that it's reviewing partnerships like this, in particular between Microsoft and OpenAI. And we've seen similar investigations at the European Commission. So definitely something that's been attracting attention from regulators in all different areas of the world. And I think that in addition to that, we see public statements making it clear that these partnerships in any form of M&A that touches the AI technological space is going to be closely scrutinized. FTC Chair Lina Khan, for example, has expressed concern that these alliances might undermine innovation, and it's clear that it's going to be a continued focus at the agencies.
So, I'm interested in trying to understand how this dynamic is new. Obviously, deploying it within AI and the focus and attention that AI is getting, that's a unique concentration of these issues. But the idea that, all smaller companies have the ability of competing in a space that has a significant amount of upfront capital needed to be able to thrive in that space, I don't think is new, right? In other words, that has been an issue that's been around for a very long time. So why is it that we're feeling like this is a focus of the FTC and of antitrust regulators, that we're trying to give a level playing field in this way for those small upstarts versus those existing large actors?
Well, Scott, I think it's in part because of the concern that Edith rose at the top, which is the urgency that a lot of the regulators feel in this space. And there's a recognition as well that AI is going to become increasingly important in all sectors of the economy and touch more and more goods and services that the American consumers rely on. So I think that's certainly one aspect that might be driving that urgency in this space in particular, even though traditional competition concerns certainly apply.
And certainly don't want to dismiss those traditional competition concerns, Scott. A lot of the principles that we're seeing and a lot of the issues are very similar to concerns that we've seen before, for sure, but they are being applied in a new context. And let me give you a couple of examples to delve a little bit more specifically into some of the legal issues that are coming into play. So, for example, as we've been noting, there are these new alliances, these new partnerships that we see. And one question that is raised is, are any of these arrangements, are they mergers? Do they have to be disclosed as a full-scale acquisition and notified, and do the parties involved have to go through an extensive merger review process that in the US can take 9 months or more, or are they not? One transaction that's garnered quite a bit of attention recently was a deal between Microsoft and Inflection, a young AI company. Microsoft agreed to pay Inflection more than $650 million for a non-exclusive license to sell Inflection's AI models. And as part of that deal, Microsoft also hired most of the company's staff, including Inflection's CEO and founder. And I think the question is being asked, is that a de facto merger? So that's just one example of how even traditional antitrust principles and doctrines have to be applied in new situations. I'll note, just going back to this question about, is a particular transaction a merger? Does it need to be notified under the Hart-Scott-Rodino requirements? In the US, both the DOJ and the FTC have the authority to look at transactions regardless of whether they have to be notified. And the agencies have traditionally have made very clear that they're going to look at transactions that they feel might lessen competition, even if they don't have to go through the HSR process. And more substantively, the agencies would be looking at, does a particular deal, is it going to lessen head-to-head competition between the two parties at issue? Might it change the incentives of the two parties to compete less with each other? Might it also impact the way that the larger player is interacting with third parties in a way that might reduce competition? So those are just a sampling of the issues that an agency would be looking at when evaluating and assessing the competitive impacts of these types of arrangements.
So if I'm getting this right, the dynamic here is that we all agree that in order for you to be successful in the AI space, some of those key things that you've mentioned, Edith, around access to chips and computing power and large scale amounts of data and specialized talent is effectively a requirement, but those are largely accessible only by a small number of actors in this particular space. So for those smaller companies who are looking to gain and to be able to get a foothold, they are doing these partnerships and these relationships with those larger clients and larger companies. But the FTC and other regulators are looking at those relationships almost as if they are potential acquisitions or something that would trigger a traditional type of review, looking past whether we call it a merger, or we call it a combination, or we call it some sort of stock purchase. We're going to put whatever it is, the language that is in the agreement aside, and instead look at the core component of the actual agreement and the transaction to see if we think that this would operate like a merger and thus trigger all of those review requirements. Do I have that right?
I think that's right, Scott, fundamentally, meaning the label may matter in terms of the process and the particular statute that may apply. But at the end of the day, I think the agencies will not hesitate to examine transactions, alliances, irrespective of what law they might use, but they're going to be looking at them very closely. So I think it remains to be seen exactly how they may view these, and they may down the line come out with certain guidance with regard to how they feel the issues that these transactions raise, but they'll be scrutinizing them very, very closely.
And as an example, outside the merger context, one way they could do that, another statutory authority, is in Section 8 of the Clayton Act. And this talks about an issue of interlocking directorates, the idea that a person can't simultaneously serve as a director or officer in competing firms that have certain, statutory minimum net worths. And the DOJ has made clear it's on the lookout to see if AI competitors are sharing board members, sharing executives in a way that, in their view, could lessen competition.
And what about the exclusive arrangements that I think you mentioned? In other words, if I'm thinking about the way that data often is being exchanged, there could be exclusive natures of data license relationships, or you're going to give an exclusive right to be able to look at this particular data set to develop this particular type of AI. I mean, are we thinking that that is in the direction where all of those data license relationships, especially ones that are done at scale, are going to trigger an antitrust concern?
Access to data is absolutely a concern, Scott. I think any exclusive arrangement could certainly trigger scrutiny. There may be other solutions, though, when it comes to data. I think increasingly we're hearing about the possibility that synthetic data or data that's created by AI may allow for greater access and broader access to data. So that may be a solution down the line, but certainly I think today having appropriate access to these extraordinarily large data sets is something that the competition authorities are thinking hard about.
And Edith, you mentioned kind of at the outset, if I'm thinking about the data component in particular, not all companies have access to the same data, right? There are some companies who have large concentrations of that data, so they're probably going to be better off in figuring out how to train new AI versus companies who don't have access to it. We did an episode on the Data Chronicles a couple of weeks back about scraping and how that was kind of the means by which other companies were gaining access to large scale data sets to be able to scrape it off of the public internet for them purposes of using that for AI training. Is there a trend or a thought that now kind of non-public databases would need to be more available as almost a public commodity for future companies to train AI?
We're certainly not there yet, Scott, but I think you raise an interesting question, which is to what extent might there be a need for regulation and rules around access to these critical inputs, as opposed to antitrust enforcement, which is going to be looking after the fact, are there anti-competitive problems, right? Mm-hmm. So I think that these issues and this emerging technologies certainly raise that question. And I think some who have looked at the way that digital markets developed might say antitrust enforcement is both inadequate because you don't have the tools to deal with these complicated issues, or even if you do have the tools, you come in far too late. The process itself can take years, and by the time that litigation might resolve, it's far too late to really implement a remedy that might actually address the core concern. So some argue that there needs to be regulation, and possibly the issues that you raised with regard to data some might think that that would be the way to go. On the other hand, right, others would argue absolutely not. Regulation can only get in the way of a really dynamic industry. We're seeing a lot of disruption, and it would be far too early for regulators to start even thinking about what rules might apply. But that's certainly an issue that many are thinking about. Again, going back to an earlier point I made, mindful of lessons that have been learned with regard to the development of just digital markets more broadly.
Yeah, I'm interested in both of your perspectives then about the existing tools that antitrust or competition authorities have and just how adequate they are to be able to address this dynamic, right? So we've already talked about, you're noting that there are limitations. Maybe what are the existing mechanisms under which they can enforce against for AI oriented concerns, and how would we expect that to proceed and develop?
I do think that antitrust principles and doctrine is flexible. And I think that under the current Biden administration, the FTC and the DOJ have a very expansive view of the antitrust laws. And I think they can be applied to the issues that we've been discussing. Again, you don't have to necessarily always be applying the merger rules, right? There's the Sherman Act, which can address agreements between competitors and others that might impact competition. In addition, the FTC has Section 5 of the FTC Act, which prohibits unfair methods of competition. That is widely known to extend beyond the antitrust laws, beyond the Clayton Act, but beyond the Sherman Act. And the FTC certainly has a very broad view of what it can do using that Section 5 authority. So I think that the agencies are certainly well placed to endeavor to address these issues, but I do think they need to be mindful about the innovation side of the equation and endeavor to ensure that intervention doesn't get in the way of the disruption that these new technologies can provide. So I think that's something that they're going to have to think carefully about. My sense is that they're going to likely want to act sooner rather than later, as I've mentioned, but I think you have to be very mindful of impacts on innovation for sure. I'll note that in Europe, the Digital Markets Act has just recently come into effect, and those are a set of new rules that apply to a small number of companies that have been designated as so-called gatekeepers, and they're an effort to make digital markets more open and fair. And it'll be interesting to see how those set of rules play out and whether there might be lessons that are learned in that context that might come to apply down the line when it comes to these advanced AI technologies.
Yeah, interesting. I mean, Chris, I'm interested in your perspective on kind of that another aspect here, because as I hear about, there are concerns about some of the inputs and, how is it that could create a competition, related issue. Also thinking about, some of the outputs, how those can create, some of these same issues. I think I was remembering a case from last year where there was an AI tool that was being leveraged for purposes of giving advice to companies about how to set executive compensation within a specific space. And plug in all of this data, spits back saying, okay, an executive within this area of expertise in this particular industry, gets X number of dollars. But if they give the same advice to 3, 4, or 5 competitors, then all of a sudden we have a result where all of those competitors are paying their executives the same amount. So it's kind of this interesting world of like this one to many, where you have a single technology who's being used independently by a number of competitors in the same space, which then results in a anti-competitive dynamic. Kind of interested in your perspective, and that's an issue that we think that's going to continue. And Edith, from your point of view, what antitrust tools are available to address that?
Well, I think algorithmic pricing is certainly a concern that the agencies have been addressing in public comments, Scott, or in your example, like an algorithmic wage fixing, perhaps. And the rules there are still emerging, but as Edith says, I mean, traditional antitrust policies will apply. Price fixing rules that apply to lower tech firms would still be here. It's just a question of how agencies and how courts will interpret that and how they'll apply it to more complicated questions that involve the data analytics and the technology behind it. I think what's clear is that companies should be aware of how algorithms that they use for pricing and any other competitively sensitive business decisions work. What's going on under the hood that's really driving those recommendations and those decisions, and understand that the agencies are highly alert to the use of algorithms as potential ways to exchange competitively sensitive information among firms. So I think, as Edith said, the traditional doctrines, they're still going to be in play here, and firms and people advising them should think of it in that sense. But it comes down to being very aware and taking responsibility for what data you're using and where it's coming from.
And Scott, I'm thinking a bit more about outputs as well. I should also mention that a number of antitrust agencies also have dual missions like the FTC, so both a mission and mandate to protect competition, but also to protect consumers. And they are also looking at these issues not only through the privacy lens that you've discussed with others on this program, but also consumer protection writ large. In the UK, the Competition and Markets Authority has a similar dual mission. In Australia, the ACCC similarly looks at consumer protection issues. So I think there is recognition, right, that competition is one important and key dimension of this, but that there are a whole slew of and broader set of issues, of course, that we need to be mindful of when it comes to the risks that may be associated with advanced artificial intelligence.
I think we see that in a lot of public statements from the government, from the White House. There are concerns about misinformation, about bias, about discrimination that AI could conceivably supercharge and allow to have a more lasting and deep impact on the economy. And some of these issues are sort of at the intersection of competition and consumer protection, and some are more focused in other areas outside of our day-to-day work as antitrust lawyers. But the key to remember is that the government is treating this as a whole of government multi-agency approach. And I think that it maybe will not fit as neatly into those categories. So it's going to take some creative thinking to predict sort of how the regulators are going to respond to some of these emerging threats that come with AI.
Yeah, I mean, I want to just kind of emphasize that point, and maybe with another example, because I think, Edith, you're raising a really good point about how that these issues are both, antitrust and consumer protection, in some ways data protection, kind of all the long list of ways that these that we're kind of thinking about the implications. I think an important point, though, is the one that you were also referencing, is that this is not just a U.S. issue. In other words, there are regulators around the world who are also kind of thinking about these dynamics and coming up with other solutions for them, right? You mentioned in Europe the DMA as an example of that. Interested in your perspective on, do regulators globally, or at least in kind of the Western regulators, are they all kind of moving in the same general direction, but maybe with different tactics? Or do you see that this is going to result in a different regulatory regimes that global companies will need to balance?
Yeah, I think initially, it will take time for there to be form consensus on how to move forward here, Scott. But what I have been hearing, listening to competition officials over the recent months, I think there's going to be quite a bit of collaboration already. Competition officials are speaking to each other whenever they can. And I think they recognize that it is vital for there to be a sense of harmonization, if that's possible, but certainly trending in similar directions. And so I think, while it's still early days, I think we are going to see a desire for there to be increased cooperation and collaboration across jurisdictions. And frankly, I think that to address some of the many significant issues that these technologies raise, I think there has to be significant collaboration between government and industry, as well as within, of course, across industry. Because I don't think that the challenges that you've mentioned and that Chris was just discussing, I mean, those are ones that really require a whole of government approach, a whole of society approach in order to address them.
Well, there's really a great kind of perspective. Maybe as we finish, our conversation here, I'm just interested in both of your perspectives on, how, data professionals can be able to help their stakeholders navigate these issues. Listeners of this podcast often come from a data-related background, may help on kind of data advice and compliance and kind of counseling and strategy. And so they are at the heart of kind of data-related decisions amongst many of their organizations. They may not be antitrust and competition experts, but they often be the ones to have to spot those issues. So if you're kind of giving your perspective on there are 1-2 things that you'd want to make sure that they leave in their minds, hey, if you start seeing this kind of thing play out, this is the kind of time to make sure you have an antitrust or a competition counsel on your side to be able to advise you. Interested in both of your perspectives as we close.
Scott, I think that it's important to just keep in mind the competitive value of data, both as an input and an output. By that, I mean as an input to these AI tools that the regulators are paying such close attention to and that have such a power not only of concern in their own market for AI goods and services, but in what regulators view as the possibility for those technologies and firms who own them to leverage that market power in other industries. So if you have your data in the control of your firm, and it's going to feed into a model or a company that runs it that could use it as a way to entrench its own position in the market, that's something to be aware of because the regulators will be paying attention to it. And that's data as an input. Data as an output, meaning that you should pay attention to how your data is being used internally at your firm and among competitors with AI tools, with other data sets, how they're interacting, because the regulators are really abandoning former safe harbors around information exchange and recognizing that AI and advanced data processing technologies are making it easier to draw conclusions, to synthesize from data sets in a way that could have competitive harms. So they're paying very close attention. And whenever you think about using data with competitors, interacting it with AI systems or data systems that share information with competitors, that should raise an alert to involve counsel.
The fact of the matter is that any alliance, any collaboration here is going to spark interest. And I think that any company that is in this space needs to be really thinking hard about competitive impacts and getting their competition counsel involved early and often.
Yeah, both great practice points. Edith, Chris, thank you so much for joining the podcast. Enjoyed learning more about how broadly the antitrust and competition issues are going to be applied in this particular space. Be a fascinating area to watch. With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.